Ladies and gentlemen, good morning, good afternoon, and a very good evening to each of you joining us for this webinar. Thank you for taking the time out to be with us today, and a very warm welcome to the Khaitan and Company M&A Academy program for what is our fifth webinar in the series. We look forward to your company throughout the remainder of the series as well. We've been thrilled with the response to this year's M&A Academy program, and we're very grateful for the interest and support with which our clients, associates, students, and other stakeholders have shown this year. My name is Surbhi Kejriwal. I'm a partner in Khaitan's M&A corporate practice in Mumbai, and I'll be a moderator for this afternoon. The slide in front of you tells us about the agenda for the program. The M&A Academy program is basically designed to provide foundational legal knowledge and understanding on M&A transaction and processes to various stakeholders, corporate executives, in-house legal teams, commercial teams, and others participating or interested in M&A activity in India today. The topic for our webinar is overseas acquisitions by Indian companies. Just a little bit on the format for today's webinar. We have an expert panel discussion followed by an audience Q&A session. Those of you who've registered with us have already sent in several audience questions. And if you do have questions, please submit them through the facility provided on the webinar portal. I'll try my best to cover all the questions, but due to time constraints, if I'm not able to do so, be rest assured that we will respond to each of your questions. We will also share with you a copy of the presentation, our summary notes for the discussions, as well as a recording link for this webinar that will be sent to you on your email IDs. I'd just like to introduce the M&A topic that we have for the webinar today. M&A, as you know, is a significantly important part of our firm's practice with more than 50 partners dedicated to this area because of the sheer amount of work and activity on M&A deals. The topic we have today is significant in the overall Indian M&A landscape. We all know that India is a preferred destination for inbound M&A activity and inbound investments. But with India being the fastest growing large economy in the world, India Inc. is now increasingly confident and is looking at overseas acquisitions, seeking greener pastures overseas, both in Asia as well as outside Asia, across new markets, new sectors, and various jurisdictions. There are several important considerations that an India Inc. will have to consider while making overseas acquisitions outside India, whether it's the interplay of the existing exchange control regulations, cultural alignments, and various other aspects. Given the importance of overseas acquisitions and consequent exits by Indian companies, we thought this was an important topic for us to cover for this webinar. I'll take a couple of quick minutes now to introduce our panel. Those of you who've registered for our webinar would have already received their bios, so I won't spend too much time introducing our panel, but I'll do a very quick round robin. I have with me Karun Karyappa. Karun is an M&A corporate partner based out of Singapore, a jurisdiction whose importance cannot be overemphasized in the context of the topic that we have today. From Chennai, I have Vivek Shriram joining us. Vivek is very, very closely advising several Indian conglomerates in consolidating overseas acquisitions. Our third panelist is Kapish. Kapish is joining us from our Mumbai office and is involved very closely again in undertaking several overseas acquisitions for startups as well as big Indian companies. All our panelists have had myriad and interesting experiences in advising India Inc. on overseas acquisitions, and be rest assured I'll try my best to leverage this experience for our webinar this afternoon in what promises to be a very, very lively discussion. Without wasting any more time, I'll start straight with the questions now. Vivek, I want to start with you. What do you think are the key success factors that an Indian company must, consider before making an overseas acquisitions? Given your experience in this sector, what do you think the Indian companies have gotten absolutely right or have to get absolutely right when they make an overseas acquisition?
Sure. Thanks, Ruby. So, I think obviously there are a myriad of factors which go into any M&A, especially insofar as an overseas investment is concerned. But some of the key aspects that you absolutely need to think about upfront, I think the first one would be obviously your acquisition structure. It's not uncommon to see Indian groups make ODI investments through special purpose vehicles outside India. So is it important to kind of do the investment from India? Or would you rather do it through a special purpose vehicle outside India? And why would be one key question to answer. And I think there are a few considerations which go into that particular assessment. Does the investment need to be done by way of a debt investment, or does it intend to be done by way of equity? Because under ODI norms, you cannot make a plain vanilla debt investment from India without an ODI investment. But if you're looking to really do, for downside protection purposes, maybe just do pure debt, then, we've seen instances where people structure this through an offshore vehicle. uh, Ease of exit of your investments. You have minimum holding norms under the ODI regulations of 1 year now. But are there instances where you'd probably want to exit within a year's period? And if so, then is there a way to, structure that out? So obviously there are a number of aspects which go into this question. The second key aspect is probably getting your advisors right. Of the manner of deal making in India and outside India vary. There are new concepts. Not all regular M&A terms that you typically see in an India transaction may apply in these overseas jurisdictions. So you really need somebody who understands the local market and is able to kind of advise you and understanding where your risk threshold stands while ensuring that they're not really being a cog in terms of getting the deal done. And to avoid protracted negotiations in that sense. The third key aspect would really be to understand whether you're getting your India regulations right. Obvious aspect to bear in mind. From the standpoint of the ODI regulations today, while you have relaxations around round tripping norms, there are requirements to ensure that that doesn't result in more than two layers of subsidiaries. And obviously you have layering restrictions, for example, under Indian law today, which prevent you from holding more than two layers of subsidiaries subject to carve outs and things like that. So an upfront assessment in ensuring that, whether you've gotten those right and whether the investment is going to breach any India regulations, I think is a key aspect. And the fourth is, really understanding any local regulatory norms in the jurisdiction that you're investing. Is there any specific requirements that you need to meet under the local laws? Does that need any resident director from that jurisdiction, or are there any other approval requirements that are needed? I think all of these, I think, would be the key aspects that you need to bear in mind when even exploring an overseas transaction upfront. And you need to have these answers upfront even before you get into take the conversation forward.
Absolutely, Vivek. I think homework is the key here, especially when you're venturing into jurisdictions that one is not very familiar with or hasn't done too many transactions. Karan, I want to come to you, and we've understood what we need to get right. Given your experience and having advised on several such transactions, give us a few examples of what you think companies have not gotten right. What could they have done better for a smooth acquisition overseas?
Thanks, Surbi. I think Vivek touched upon a few of the topics that are necessary for you to get right when you do an overseas acquisitions. The corollary to that is, of course, getting things wrong. Do you actually understand the country that you're walking into? What are the regulatory aspects that you need to keep in mind? If you've underestimated what the regulatory issues are, then obviously that can derail your entire acquisition. How will you, if you are not familiar with the country, how will you try to mitigate the risk of country familiarity? Due diligence, obviously, and then reliance on your advisors. Now, if you have not done your due diligence, or if you are not relying on your advisors, then I think you can come up to a sticky end. The other is, of course, from a business perspective, a lack of transparent financial statements, a lack of undertaking integrity due diligence, making sure that you have familiarity and a meeting of minds between the management, making sure that the business plan that you have is also something that goes on from year to year. Now, from a regulatory perspective, it cannot be underestimated. The entire issue of whether you require approvals in that jurisdiction, that is pretty key. You've got foreign direct investment restrictions these days which are applicable. That's something that you need to definitely keep in mind. What are the timelines for obtaining these FDI approvals? What are the timelines for obtaining merger control approvals? Those are also aspects that you need to keep in mind. Now, interestingly, quite a few jurisdictions, including the US, the UK, and even in India, we have Press Note 3, which restricts certain investments from certain jurisdictions. Now, similar to that, if you're making an acquisition in, say, the United States, you have US securities concerns which come into play, especially if there is an element of defense that your target actually undertakes. So you need to obtain, or you need to do an analysis of whether you need to go and obtain CFIUS, which is the agency which gives you approval when you're undertaking an acquisition. For example, there was a few instances in the past where Broadcom was trying to acquire Qualcomm. That was scuttled because CFIUS approval was not obtained. So this is something that could derail your entire acquisition. The other is understanding some deal specific nuances. One common element that we always negotiate for is non-competes. The target that you're acquiring, if their founders or if their senior management undertake competing businesses in the future, how will that impact your target's business? So you've got to understand in certain jurisdictions, a non-compete may not be enforceable. So one is to take country risks, say in the US, but then the other is if you go to California and your target is based in California, then you need to understand that non-competes may not be enforceable. There are, of course, certain exceptions to that, but you need to understand that. And if you as an acquirer have not factored that in, then obviously this could also come as a surprise. And then, you end up obtaining a target where, the key management personnel have gone and started another company which competes directly. So that's an issue. Lastly, understanding labor issues. Now, depending on what you want to do, if you're acquiring an entity and taking on their entire labor force, then you need to engage with labor. This is particularly prevalent in Europe, and many times you find that acquirers are very surprised with the slow pace at which you engage with unions. So these are a couple of instances where we've seen deals being derailed, and I think it cannot be emphasized that you need to do your homework in advance, like Vivek mentioned. And once you get it right, then of course rely on your advisors to take you across the finish line.
Yeah, absolutely. And speaking of homeworks, structuring is, Kapish, an exceedingly important part of any acquisition, whether it's overseas or domestic. Specific with regard to Indian companies acquiring companies overseas, what are the typical structures that you're seeing Indian companies adopt?
Thanks, Ruby. I think when you're looking at an overseas acquisition, the world is literally a oyster. So, you have a plethora of options available, structuring. You could pick any country you want to set up a holding company, or you can pick any country to do the final acquisition in. So there is, of course, to subject to Indian regulations and certain restrictions, it's fairly open field. Uh, the factor obviously is that there is not one structure that fits all. It has to be your bespoke structure that works for your deal. So, for example, a deal of a minority VC funding or a minority acquisition will be very different from a strategic acquisition, right? The structure needs to make sense for you and for your company and for your structure and for your operations. Vivek's already mentioned, I think our most common structure is to set up a holding company in one of the tax efficient jurisdictions. Karun is sitting in Singapore. You pick up the phone, call up Karun, set up a company in Singapore, and then use a Singapore entity or a Dubai entity or Dutch entity to then further make downstream investments and acquisitions. We like that for a variety of reasons. Of course, tax efficiency is one. Second, obviously, is the fact that you have downside protection. Your Indian balance sheet is not exposed to the sell side. You also have other protections available. It also opens up ability to leverage offshore funding a little more efficiently. It also opens up the ability of possibly monetizing that asset alone offshore and not in India. Though, increasingly we are seeing an India heavy monetization strategy, but that we always like to keep our options open when we are doing acquisitions because we don't know what the future will hold. We've also seen a few interesting deals where it's not been a plain vanilla holdco acquisition. We've helped companies structure a deal wherein you have acquired a target offshore against fresh issuance of shares in an Indian company. And the sell side wanted liquidity of the Indian capital markets. We structured a deal where the acquirer would have issued them fresh preferential share allotments, and that's something that can be looked at, and it's possible. There are lock-ins, but it's not an insurmountable challenge. And nowadays we are seeing Indian companies being more and more aggressive in the way they are structuring deals. They are looking at hybrid instruments. They are looking at offshore leverage. They are looking at onshore leverage as well. We are looking at a lot of permutations and combinations. Sometimes we forego even acquiring assets directly. So especially in your pharma sector, you're seeing a lot of in-licensing, acquisition of the license that comes in without any move of company itself. You house the IP in India. You also have in the retail space a lot of action on the brand acquisitions. So you create a JV in India, or you create an entity in India and just outright buy the brand, the retail brand from the offshore entity, and then operate it out of the Indian entity.
Yeah, absolutely. And I think Indian acquirers are getting creative. They're getting more confident, exploring a lot of other options, taking a leaf from out of their US counterparts, where swap cash plus stock is a very, very common structure that any US company would adopt. Cuts down their cost of raising capital. But of course, swap has its own set of very unique challenges under the Indian exchange control norms. Which brings me, Karan, to you. Speaking of uncertainties in this Indian exchange control norms, we've all sort of been living with the old ODI 120 or FEMA 120, which has been replaced by a new set of regulations. In your view, have those changes had any significant impact in the kind of acquisitions or the amount of acquisitions that you're seeing? Do you think it's eased business for Indian companies? Or do you think it's just the same?
Look, I think when you're undertaking an overseas acquisition, you need to have a very sound business case. Now, I think with the new ODI regulations, Indian corporates do have that flexibility to be able to acquire assets overseas. But of course, just because there's been a change in the law, it doesn't mean that the floodgates have opened with respect to overseas acquisitions. That said, what we have been seeing is a proliferation of family offices in various tax efficient jurisdictions. Like Kapish mentioned, there are capital controls when you invest from an Indian entity overseas. So when you have your family offices or overseas sort of SPVs which have been structured, then it makes it easier for you to undertake various acquisitions, other sort of capital fundraisings, seeking certain investments also into your holding companies or your SPVs. So there's a lot of flexibility that is brought about when you undertake these family office acquisitions, incorporations. Now, Singapore is one very, very popular destination. The other is Delaware, and the other is also Dubai. So we're seeing a lot of inquiries coming in about setting up family offices. Singapore itself has about 1,400 family offices that have been set up. And of course, there are a lot of questions that keep coming to us on what's the best way for us to structure it? How do we do so? And then once we do so, what are the regulatory compliances that we need to be mindful of in order to continue with those operations? What are the costs also involved? So without having a business plan in place, all of these steps, will not take place. So it has to be a conscious effort and a plan by the Indian corporate to undertake overseas acquisitions.
Absolutely. Thank you, Karan, for that very succinct summary of some of these uncertainties. Kapish, I want to quickly take your views. You mentioned a little bit about the SPV structure and debt and things like that. What are the typical sources of financing for India Inc? How are they financing their acquisitions?
So it depends on the company. We've seen a lot of action from the strategics who are looking to acquire ancillary vertical, horizontal acquisitions, or even bolt-on acquisitions across the globe. So in these circumstances, for our strategic clients, they typically already have great working relationships with banks in India. And at least in our experience, banks in India have been, while they're expensive from an interest point of view, they are comparatively more flexible. They have familiarity with the client. They have the ability to bend over backwards, move quickly, get credit lines issued quickly. Have the structuring in place. We have sometimes struggled for the same amount of speed from offshore banks. I'm not saying it's a blanket case. There have been instances where offshore banks have been helpful, but to create a new relationship is time consuming and may not be possible for an overseas acquisition. So we've seen predominantly most of the overseas acquisitions being either funded through internal accruals or just through the financing existing or fresh ones from Indian banks. Karun and I have already mentioned, Singapore is a hot destination. The debt market there is world famous. There are instances where debt's been picked up in Singapore for your offshore acquisitions. In that case, you leverage or you pledge the shares of your target itself and use that target's entity to do acquisition financing. We've seen an interesting alignment of Indian banks moving to GIFT City and using the GIFT City structure to fund in dollars and euros basis a parent company back guarantee. So historically everybody had UK branch offices which used to deploy offshore, but now we're seeing increasingly it's coming out of GIFT. So that's something that a few of our clients have tapped into, not only for acquisition financing but also ongoing financing for operations of the offshore entity, so that they have the comfort and the pricing of the parent company's balance sheet. There's a guarantee there, and Indian banks are very comfortable with that approach. Of course,
Right, right. Thanks.
if you're picking up a entity which has financing, then that's the best. So you just leverage of that financing there.
Sure. Thanks, Kapish, for that. Vivek, I want to come to you and maybe, get a little bit more granular on the ODI norms and the uncertainties surrounding ODI norms. But before I do that, requesting our audience to keep sending in questions. Please use the facility on the portal, and we'll try and take as many questions as we move along this webinar. Vivek, right, coming to you, do you want to take us through some of the poignant issues qua the ODI regulations? What's been good, what's been bad, what's been ugly?
Sure. So I think clearly been an earnest attempt to ensuring that some of the questions that were raised under the earlier regulations are answered under the new regulations. But as is the case with any new set of norms, there is a learning curve. Practitioners are being faced with questions on a daily basis. AD banks are grappling with some of these issues. But let me maybe just highlight some of the common ones that we've typically faced. The most common question which pops up is with the relaxation on round tripping norms. How do you calculate the permitted number of layers? I think the regulations as they read today permit a financial commitment back into India so long as it doesn't result in more than two layers of subsidiaries. And the question really which comes up is, where do you start calculating these subsidiaries from? Do you calculate it from the Indian company, or do you calculate it from the first level of the overseas investment outside India? And that's something that we get asked quite often. I think in terms of where we stand today, there is sufficient clarity, at least in the sense that you start calculating the two layers of subsidiaries really from the first level of the offshore vehicle and not the Indian company. But again, you need to bear in mind that the way subsidiary is defined from an ODI regulation standpoint is not the common Companies Act definition, but control is pegged to a 10% shareholding threshold. So you need to bear that in mind, that it's very easy to kind of just look at subsidiary and just say, okay, fine, it's not a subsidiary, and therefore you can kind of do what you want. But that's the small loop in the law that you need to be mindful of. The second common issue, and that we get faced with, is today the regulations permit deferred consideration structures. But then again, where an Indian party sells or divests its ODI holding, there is a requirement to repatriate funds back into India within a 90-day timeline. Now, while one provision provides enough flexibility in terms of deferred structure, there's a requirement to repatriate that back into India within 90 days. So how do you kind of align these two provisions, and where do you stand in? So does that mean you can't defer more than 90 days, or is there any other view permitted under these norms? And we've had different experiences with different banks. Some AD banks are comfortable taking a position that so long as you're able to repatriate the fair market value of the sale into India within the 90-day time period, you do have the flexibility to defer the balance out. But again, I mean, there is nothing in the letter of the law which expressly permits you to do that in that sense. So there is still a little bit of gray around that particular piece. Just staying on to a similar issue, let's assume that there is an Indian seller who wants to sell to an offshore buyer, an ODI investment. Now you have a requirement to repatriate that back into India within 90 days. But let's assume that that's backed by an Indian guarantee. And if there is a breach and the guarantor in India actually discharges the guarantee obligations to the Indian seller, how does that play out from an ODI standpoint? Does that mean that the Indian party has discharged its obligation of repatriating that funds into India, or is there still a potential non-compliance or a gap in how do you even report something like that to the RBI? How the RBI would react to such a situation? I think those are issues which are still being addressed. There is still not enough clarity on that, and I think we'll need to kind of wait and see some of these situations to play out, and maybe so it's a learning game in that sense. But these are at least I think some common instances that you can kind of.
Thank you, Vivek. I think those are pretty significant issues, when you're talking of deferred consideration, indemnity, and whatnot. Um, Kapish, I want to pick your brains on a couple of issues really. One is in terms of the due diligence. Now, when we as Indian acquirers are undertaking a due diligence of the target, what is your approach towards the due diligence? A. And the second part that is linked to this is, what are the entry norms? Like, for instance, if a foreign player were to enter India, there are three or four big ticket items that sort of come to our mind as transactional M&A lawyers. Do you see similar issues in overseas jurisdictions? Maybe if you could just, give us two or three specific examples of some jurisdictions that you've worked on, that would be helpful.
Yes, Surabhi. Uh, on the diligence point of view, if you ask me, are you looking at diligence differently from an Indian acquisition, a wholly Indian acquisition, to an overseas acquisition? The answer is yes and no. The yes is that from a target point of view, the operations management, the contracts, material contracts review, employment labor law review, it's predominantly the same. We will have the same materiality thresholds. We would have typically the same amount of diligence, a red flags report, etc. The amount of extra, and Karun and Vivek have both touched about it. The most important thing for an offshore acquisition is knowing the local laws and knowing the local regulations, the lay of the land per se, right? So we spend a lot of time in an offshore acquisition understanding the regulations that impact your operations and impact your business. It's not as simple as just appointing a local advisor. You need to appoint a local advisor and ask them the right questions, and that's where we help. We it's not the fact that we get a DD report and it's good and it's done. We need to flag what is it that you as a general counsel or an in-house counsel or as a part of the acquirer have to live with. Like one of my examples is I was advising a BPO client of ours. We were doing an acquisition of a BPO in the US, but the BPO helped in chasing bills for hospitals. And in that, they had access to patient records, and therefore they had to do HIPAA compliance, which is basically typically restricted to hospitals and other Medicare providers. So it's a unique challenge. So while everyone keeps talking about ease of doing business, while globally there's ease of doing business, everything comes with a penalty. So it's a light touch regulation, but if you miss the regulations, the penalties are severe, which may or may not be the case in India. In India, it's more overly regulated, but the regulators seem to be more forgiving of minor non-compliances. So that is a mindset shift that some of our Indian clients have struggled with, have suffered for. that in some of the cases there's class action suit risk in the US. There is a ticking time bomb of a $2,000 fine for every fax which is sent out unsolicited. So there are hefty fines which are sort of hidden in the regulations. So that is something we really focus on when we are doing offshore acquisitions. Keep going with our eyes open. On entry barriers, yeah, we are increasingly seeing, I think Karun mentioned it in one of his previous answers, we are increasingly seeing a lot of entry barriers being created. And that's not an India specific entry barrier. The world itself is moving away from globalization. I like to break it into two parts. There are places like Singapore and Dubai who are welcoming foreign capital. UAE removed the restriction on the 100%. Now and entities can be 100% owned in UAE, which was previously not the case. There are openings in certain jurisdictions, and certain jurisdictions are reacting to the larger geopolitical and political issues and closing borders. So, for example, Germany now has an FDI requirement, right? There is a post facto notification, but there is a risk that the government may annul the transaction. So, increasingly in Germany, we are looking at doing FDI approvals upfront. In cases all over the world, we are now seeing an increasing scrutiny on UBOs and SPOs. In India, we call them SPOs, but globally it's UBOs, the ultimate beneficial owner. We are even in India, right? So we have SPO filings now, but every country has different regulations and different rules for the same issue. So we have been historically been struggling to keep a uniform UBO declaration across multiple jurisdictions, because we don't there are two positions here. There's of course one is to the regulators with the letter of the law, and two, as an entity with global presence, it's about uniformity and your public image. So you cannot have different disclosures to different regulators just because the letter of the law says so. So we've been struggling with that also in recent acquisitions to make sure that our pack and our disclosures of quote unquote promoters is consistent with our UBO declarations of offshore.
Absolutely. Thank you, Kapish, for that detailed response. Karan, I want to pick your brains on one term, that we keep hearing and we've all dealt with, called reverse flipping. Now, for those members of our audience not familiar with that jargon, I'll just de-jargonize that. Reverse flipping is nothing. So basically, what was happening is that a lot of the startup ecosystem was the ownership of the startup ecosystem was housed overseas through a holding company, and Indian promoters were also taking stake in that holding company, and all the series financial sponsor investments was happening in that offshore holding company. For various reasons, that structure is now being flipped to say that that holding company is now being mirrored as an onshore holding company. So that is what is usually known as reverse flipping. What I want to understand, Karan, from you is what's happening? Why do you want to reverse flip? You've taken all that trouble to, and we've talked about SPVs so much. All three of you have sort of talked about it. What's gone wrong? What happened?
So look, I think like we've been talking about, when you have an external holdco structure, there are, lesser capital controls, at least from an Indian law perspective. So I think from a company's perspective, there were two reasons why they were externalizing or, setting up overseas holdcos. One was obviously a business case. The business case was, you captured value when you had an offshore holdco, and that offshore holdco could then go and acquire assets overseas, complementary businesses that could add value to the existing business that you were running out of India. So we've done a few of these acquisitions where, there was an Indian entity which wanted to acquire a business in Indonesia, and they had a flip structure which was the most conducive. Now, the second is monetization. Now, a lot of VC funds were advising Indian founders to go and set up offshore holdco structures. The reasons were, you could capture value under this holdco, and by virtue of capturing value under this holdco, you had access to more capital in these jurisdictions that you set up your holdco structure. The other was that it was easier for you to do a de-SPAC And the third is that you always had the option of doing an overseas listing on the NASDAQ or any other, of those stock exchanges. So now, as a result of having these external sort of structures, there's as this has evolved, there have been a couple of issues that have cropped up, so to speak. One is we don't really have a de-SPAC market anymore. From the last time I checked, I think there was only one de-SPAC that has successfully been conducted out of India. Even Singapore has had probably one blockbuster de-SPAC, which was the Grab de-SPAC, right? Now, in order to list overseas, once you've undertaken the listing overseas, people are finding that unless you are above a certain market capitalization, there is less volatility in your stock in those overseas stock exchanges. And as a result of which, there's not much research, there's not much noise that is being made about your company in those markets. So I think founders and promoters or major shareholders are struggling to understand where they can get their next value from, right? So right now we're seeing a very, very buoyant Indian market, as a result of which a lot of these companies that had set up overseas holdco structures are looking to flip back into India. And the reason for that is, you have a very robust IPO market, you've got a lot of retail investors, there's familiarity of overseas institutional investors with the Indian market. They know that they can invest in an Indian company that is listing, and then over a period of time, they can successfully exit from that company. So all of these factors are coming to play these days, where we're seeing, most recently there was a payments company out of Singapore, which at least for quite a long time was seeking approval from the Singapore courts for them to merge back into India. That approval has come through, and now that process is ongoing. We are, of course, getting a lot of inquiries of companies that had holdco structures in Delaware also, who are trying to figure out what's the best and most efficient way for them to flip back into India. There are certain tax considerations that people are grappling with at this point, but this is the genesis of why people are doing these reverse flips back into India.
And you think, Karun, one of the reasons for reverse flipping is that in because of the complications around round tripping, at least in the earlier regime, you were actually just cutting out Indian funding. Because if you had an Indian company, let's say, pick up a stake overseas, and then again you would have something below, you would get into complicated structures like a shadow stock. And I mean, I don't want to bore our audiences with a hefty dose of, again, jargon that we like and we feel nice and important about it. But you think that was one of the reasons, but with the liberalization now or the clarity that we now have on the two layering, you think that is not a reason for reverse flipping, or does that still play a role?
Look, I think, like I said, it's all pretty much a business case, right? Where do you actually capture value? So I think in the, prior to the ODI changes, there were mirror structures, shadow structures. There were a lot of options and structures that we thought through and which we'd implemented for a number of our clients, which complicated the entire cap table, your rights package. How did you reflect the rights package at the whole co and also at the subsidiary co in India, the operational company in India? All of those complications were things that were added to a lawyer's fees. So I think those are very welcome from our perspective, but a bit of a nightmare when you're looking at exiting down the road. So, and I think a lot of people also realized that there was too much brain damage, so to speak, that was being undertaken when you are undertaking these structures. But now you're right, these ODI regulations have now simplified what you can do. Kapish and Vivek have talked about SPV structures. So now you can still capture value under your Indian entity. You can have an offshore SPV which can undertake its acquisitions. So from a liquidity perspective, from an ultimate exit perspective, from a fundraising perspective, I think it's a cleaner structure now that we have very welcome ODI regulations in place.
Right. Thank you. Thank you, Karun. It's the wedding season. Vivek, I'll come to you. We're not talking of weddings in this webinar, but what I want to understand from you, Vivek, is doing an acquisition. We're all talking about how to make an acquisition and how to exit from the jurisdiction, right? Nobody's talking about the relationship per se. Um, Post integration issues is something that we've all grappled with for inbound investments. How do you think that pans out for overseas acquisitions, particularly for strategics, the kind that you advise, who are not entering the fray to exit, who are entering to stay there for the long term, and they want to create value and then upstream that value towards their own Indian listed company in several instances? So post-closing integration, how's that panning out? What's been your experience?
So no, absolutely, Survi. So I think that's absolutely key in terms of any transaction, right? You can get through FEMA and all the hurdles and all the loopholes through that and make a big bank acquisition. But if you don't get the integration right, then as Karan briefly spoke about earlier, that's a recipe for disaster. But in terms of integration, I think there are clearly two parts to it. One is more the softer aspects of practices, cultural integration, and things like that. And then there will be the second leg of integration, which is more operational in nature. And clearly, both are equally important. But just sticking to cultural integration, this is absolutely key, especially when you're investing in a different jurisdiction where practices vary, people's cultures vary. A example that at least I've come across where a significant discussion of a conglomerate which happened is do employees of the targets need to start wearing uniforms to office, because that was a practice back home in the Indian conglomerate. Now that was a significant topic for discussion with the with the offshore target, because that was not the practice back there. And it's common to see you don't have to kind of necessarily apply everything that gets applicable in India back to these offshore targets. I think you need to kind of be nimble and flexible in terms of what you want to kind of impose and what not. It's key to ensure that you do have ears on the ground. If you're not, especially if you are entering into a new market which you're not aware of, it's important to have trusted people on the ground who are able to actually relay information back home, so the Indian promoters or the Indian board is aware of what's happening, what's right, what's wrong, and so on and so forth, especially in the early days. And also building trust with the local management, the employees, with a new acquirer, I think is absolutely key. The last thing you want is a disjointed workforce with a new target, and not an unmotivated, non-motivated workforce in that sense. So cultural, and this is something that you need to start planning way ahead of even entering into the transaction. So in fact, it's not something, I wouldn't say it's actually while it's post closing integration, I think you need to plan for it much way ahead, even actually before getting into documentation and things like that, but you have a clear plan. On the operational synergies, I think this is more a mix of maybe what you need as per your internal policies and maybe aligning with what your local law requirements are. So let's assume you have a listed company which invests in an offshore entity, a startup, which then gets called an associate company or a subsidiary or so on and so forth. You may have local law reporting requirements from a financial standpoint to SEBI and so on and so forth. But does the offshore target follow the same financial year? Do they have the systems in place to pass this information back to you so you're able to integrate those into your financials? Those are systems that you may have to build as you're looking at some of these aspects and to bear in mind. So that's really, and absolutely you'll have to get both right as you look at any of these acquisitions.
Thank you, Vivek, for that. Gentlemen, I'm cognizant of the time. I think we just about have time for one more panel question, and then we'll start our audience Q&A. So, requesting the audience to keep sending in your questions for our panelists. Um, Kapish, let me start with you. If you were to maybe pick two significant learnings um, in terms of doing deals overseas, need not be purely legal, could be in the way one runs a deal, could be softer aspects, maybe just one or two very quickly, and then I'll go to Vivek and Karun as well for the same question. But what, according to you, are the one or two most significant deal learnings?
I think the most significant deal learning for me is just patience. And the second would be culture. So, number one, It's going to be a slightly more complicated structure than what you are used to with an Indian acquisition. So you should be a little more patient when it comes to everything. There are a lot more advisors on the table. There are a lot more parties on the table. Everything is a little more complicated. It's an additional layer of complication. It's not insurmountable. You just need to be patient and well organized, and that's what we are specializing in, right? We know how things go. We know what are the pitfalls, so we can work with you to set up a reasonable timeline. So that is one thing. So there is an extra amount of patience required. The other thing is to be factored in. Vivek's mentioned about post-integration culture. You should also, culture is an ever-flowing problem across the deal. You need to be sure that when you're negotiating, also to factor in the cultural aspects. Like we were advising a client on a German acquisition and a Japanese acquisition at the same time. We negotiated both of them very differently. So depending on your counterparty, and I'm not generalizing here, of course, but you may want to factor in and analyze whether a no is a maybe or a maybe is a yes or a yes is a no. So those things, those are the finer nuances that you of course pick up as you go along when you're negotiating with different counterparties. But that's something you should factor in your deal structure.
Vivek, what have been your most significant deal learnings?
So I think one of the key aspects is being flexible in terms of how the documentation turns out. I touched upon it briefly upfront, but it's not, some of these concepts that we typically see in India M&A may not apply or may not even be relevant from an offshore standpoint, or may not be accepted because local markets and norms vary. So I think it's important to have that understanding. Otherwise, you run the risk of just running into protracted negotiations, which probably doesn't benefit either party in that sense. And that goes around with having the right advisors on board. I think the second key aspect is to have a clear exit plan. Especially critical in terms of joint ventures and so on and so forth. The last thing you need is, if things go south, to be stuck because either your deal documentations don't give you that flexibility, or you're stuck because of regulatory reasons. So it's while everything is good in so far as the investment is concerned, I think it's important to have the ability to exit if you really need to and you want to press the nuclear button at some point.
Karan?
Look, I think two pieces of advice that I would give, potential acquirers are caution and trust. Caution because you're walking into a completely new jurisdiction. Now, there will be nuances, there will be jurisprudence, there will be customs, nuances, etc., that you need to understand. So you need to understand completely what the risks are, what the pros are, what the cons are, why your contract is drafted in a particular manner. I talked about non-competes earlier on. Is that enforceable? Is it not enforceable? Is there judicial precedent which says that this is a certain way in which the courts will take a look at a particular clause in a contract. And of course, if you're acquiring an asset in a civil law jurisdiction, then obviously it's a completely different kettle of fish that you need to figure out. Trust, like I said, it's walking into a new country. You need good advisors. You need to be able to trust your advisors. Your advisors are there. They have the experience. They've kicked the tires. They know what way the law sort of rules when it comes to certain sticky issues. So trust them and heed their advice. So these are the two sort of learnings that I always encourage my clients when they're doing overseas acquisitions.
Thank you so much for that. While I'm sure there are several others, but these are the key issues that maybe at least some of us should keep in mind. We have just about, I think, 7 to 8 minutes left for taking some audience questions. We've received a few of these. Vivek, a lot of our audiences have the same question. I think we did touch upon it during the presentation, but you want to just take them through the calculation of the layering of the subsidiaries. We've got 4 or 5 questions on that. So maybe we can just revisit that part for our audience.
Sure. So, I mean, under the earlier regime, obviously, any round tripping structure required prior RBI approval. As per the current norms, an Indian entity can make a financial commitment which results in investment back into India so long as the resultant structure does not result in more than two layers of subsidiaries. Now, therefore, when you want to calculate how those two layers are calculated, you look at it from the standpoint of your first level ODI investment. So let's assume Indiaco. Indiaco has a Singapore entity B. B has, let's say, another subsidiary C in Dubai. So Dubai entity can then have an investment back into India, and that's fine because you're calculating the two layers of subsidiary from the perspective of the Singaporean. What you can't have is another layer in between the Dubai entity and the India entity. That would effectively breach the round tripping structure. So that
Right,
kind of
right.
addresses. Yeah.
Karun, specific question for you. Again, I think you did touch upon this issue while responding to one of the questions, but can a merger with a Singapore company be done of an Indian company? Is what's happening over there on that front?
Yes, this was been the bane of many companies that had structures in Singapore. So right now, the law in Singapore basically said that you couldn't really do an offshore merger of a Singaporean entity. Now, as I mentioned, there's a payment aggregator, a very prominent one, who's gone to the courts in Singapore, and approval has been given for such a merger, right? So I think this has been a very welcome ruling. So the process is in place. The courts are cognizant that this is something that people want. The shareholders have given all their approvals, all the investors have given their approvals. The company wants to do it, so there shouldn't be a bar, so to speak, with respect to this merger. And we've been talking to a lot of Singapore councils about this judgment and what it entails. What are the ramifications? What are the sort of processes for us to go and obtain this? And well, I think the ruling's out already. So to that effect, yes, a merger is possible with an Indian entity.
Right. Thank you, Karun. I hope that response clarifies the question. Kapish, one question for you that our audience is asking is, what is the role of the AD bank? You know, we always talk about this. Are we overplaying that importance, or how do we, is it a landmine? How do we go about, doing deals when there is an uncertainty, and what is the role that an AD bank can play?
Yeah, we're not overstating the AD Bank's power. Unfortunately, it's not something that we've granted to them, but what the regulators are. We now look at AD banks as a quasi-regulator for all intents and purposes, especially when it comes to ODI, right? It's becoming more and more important for them to be onboarded and signed off. When it comes to a plain vanilla acquisition or a plain vanilla structure, we don't have that much overplay in them. That's a well settled, well trod path. So you don't really need to be worried about it. But if you're coming up with a complicated structure, or if you're coming up with a view which may or may not be uh, clearly written in the regulations, any amount of, even if there's an iota of grayness in it, we like to bring your AD bank in at the earliest. So once we have a finalized structure, we run it past them just so that they don't create trouble later. Because once you have the structure frozen, you will document it basis that, you will sign basis that, and you'll close basis that. We don't want them at the time of closing to step up and say, "Hey, I'm not remitting these funds because there's an issue." So we try to bring
Right.
them up in front. We obviously limit the amount of information they get, but uh, we do take them on board and get their sign off in advance nowadays.
Absolutely. And I think the fact of the matter remains that the AD Bank continues to be the first port of call for the RBI should they detect anything that is not sort of as per their interpretation of the law. So it's only important that we loop in the AD Bank, because we don't want to be in a situation where we've structured a deal basis a certain view or certain interpretation, and post implementation the RBI has changed its stance, which they have done in the past. So it's always better to have your ears close to the ground. Thank you for that, Kapish. Vivek, one question for you, which basically is the same question, but it has two parts. One is, if you can just take us through some of the major compliances that are required by Indian companies in terms of ODI norms, other than the issues that we've discussed in terms of the bare bones compliances. That is one. And linked to that is a question specifically on ED investigations. Now, there's a provision in the ODI norms which says that if any group is under any investigation, there are a few additional hoops that they will have to cross if they were to make investment overseas. What is that provision? How are you going about that? And what exactly do you mean by investigation? If I've just received a notice, does it mean I'm under investigation?
Sure. No, why don't I take that up first? So I think as per current norms, if there is an Indian entity basically which is either classified as a willful defaulter or is under investigation by any investigative agency, be it the CBI or be it the Enforcement Directorate, etc., that entity then needs a no objection certificate from the specific agency in question or the bank in question before making an ODI investment. Now, what would constitute an investigation? I think it's fair to say that if you have just received, let's say, a notice saying that I need certain information regarding the company, I think it's fair to say it doesn't automatically mean that you are under investigation. There has to be something more of substance to justify that yes, you are under the scanner of this investigative agency, and there are some proceedings pending against a particular entity in question. An RFI should not automatically bring you within the purview. But then again, the regulations provide some flexibility to suggest that even if you seek the no objection certificate and you don't receive a response within the 60-day time period, 60-day timeline, then it's deemed that that particular agency or lender does not have an objection to your specific ODI investment. So it's not, all hope is not lost. You can still write and seek a NOC on the merits of the case, and you can still go ahead. And that's something that you'll need to look at upfront. Right? And in addition to that, I think the other key aspect that need to bear in mind is that if you have if there have been lapses on your reporting guidelines from an ODI standpoint, then you need to clean those regulatory lapses up front before making any further financial commitments outside India. And that's absolutely key. It could be legacy issues, it could be new issues that have popped up. But if you have pending reporting lapses in your system, then unfortunately you have to wait and get those cleaned up before you can make any further ODI investments. Even if, and it's a common issue, especially if you have existing overseas investments which require, let's say, capital, then you still have to clean those up before making these overseas investments.
Absolutely, absolutely. Thanks, Vivek. Gentlemen, I'm completely out of time, but I do have time for one final question. And this is my question, along with some of the audience members also asking. And Karun, I want to start with you. We as Ketan work with a lot of foreign law firms when we're doing overseas acquisitions. What role do you see yourself playing? And I'm going to come to Kapish and Vivek as well for the responses. But what role do you see yourself playing in an overseas acquisition, working alongside foreign counsel?
Look, there's a lot of value that we bring when we are the interface between a general counsel and a foreign law firm. One is, culturally, we understand the Indian client better. We understand what are certain red lines. We understand linguistically, language also, when they are uncomfortable with certain stances or certain positions, and how do we react to that. I think by virtue of us being a conduit of information to the foreign law firm as well, I think they are grateful that we distill a lot of the information that the Indian corporate requires from them, and we present it to them in a succinct sort of manner so that they also get it. They interact with us directly, and then it becomes a seamless flow of information and a seamless flow of negotiation between us, the foreign counsel, and ultimately what our client wants. So I think it's something that we bring to the table. Some of us have international law experiences as well, so we understand the ways in which foreign law firms function. So I think we can cut through a lot of that also when we discuss with our clients, and that's something that cannot be underestimated.
Right. Vivek, what are your thoughts on this?
No, I think similar to what Karan mentioned. Obviously, with experience with certain conglomerates that you work with over a period of time, you develop some understanding in terms of what are the bare minimum requirements that these clients want as just part of any investment. You just understand their requirements a little better as against foreign counsels. I think there is clear value add in terms of not reinventing the wheel and maybe doing some degree of quality control and actually avoiding a lot of the unnecessary conversation to just get to the same place. So working with Indian conglomerates helps you understand, and you understand their business better. Does a particular clause work for them given maybe some other aspect of their business, some other investment that they've made? So I think that's the value add that you can build, and helps kind of you negotiate or discuss with the foreign counsel and avoid a lot of the negotiation or conversation that they otherwise need to have with the Indian client.
Kapish, concluding remarks on that.
Uh, I think nothing like there's very little to add, but we Indian law firms have now, at least Indian lawyers now, are among the best in the world, right? I'm not just saying only of our firm, but across the board. There's been significant amount of improvement as the country has grown, and as we from 1990 to now, how every other industry has grown to be competitive in the global space. Even our industry has grown to be competitive, and M&A as a language has sort of collapsed. So there isn't really that much of a difference as to what English law is talking about and Indian. Of course, there are local law nuances. So we are increasingly holding the pen on transaction documents on M&A acquisitions. We are closer to the client. We are in Indian time. We can sit down with them. We can have a call with them. We can actually understand what they want. So we are seeing an increasing value add in actually holding the pen in transaction documents with local lawyer support. Local lawyer support cannot be understated. It is very important, but we now have contacts in almost every country in the world. We've been doing this for over 100 years. We have friends in every corner of the world. We don't have a preferential law firm anywhere. So it's basis your requirement, your price bucket. We can find out the lawyer for you. So just last week, on a Friday night, somebody called me up and says, "Hey, I need a lawyer in Barbados," and we could find it within the next 2 hours. So we reached out to them by end of day Friday, and we had a quote from them that day itself. So that amount of reach, that amount of availability is something that is only comes with the amount of practice that we've been doing in this space.
Absolutely. And I think at the end of the day, every client wants to work with trusted advisors. And it's a cap that we wear with a lot of feathers, with a lot of pride. And I think that's the most important role that at least I've seen myself play, to add on to what you all have very kindly stated, that the end of the day, if I'm the trusted advisor, I will be the one decoding perhaps a complex set of regulations to a point where the client understands, because I know what the client is used to. So that really helps things ease things out. We become the single point of contact. We bring in our own efficiencies. We understand the client's requirements over and above everything else that you all have said. Gentlemen, this has been a very, very lively discussion. I thoroughly enjoyed bringing this to our audience. I hope our audiences liked it. It's difficult to sort of pin this down to takeaways, but if I were to pin three or four main takeaways for me, basis our discussions today for Indian companies making overseas acquisitions, I would drill it down to interface with the ever evolving regime of Indian overseas investments. We don't have full capital account convertibility. I don't think we're going to get that in the next 10, 15 years. So it's exceedingly important to have that interface. Second aspect, and I can't say this enough, is a curated set of trusted advisors, both Indian and overseas, including financial advisors. And the third, and perhaps the most important thing, is of cultural alignment, not only in terms of the people and the business, but also of the law, to just understand how things work. The way things will work in Bangladesh will be very different from the way things will work in Germany, will be very, very different from the way things will work in Japan. So it's very important to have that cultural alignment. We love it when our foreign investors know our culture and know how to greet us and how to work with us. We should reciprocate the same as well. Thank you so much, gentlemen, for your time. Um, if we can just have the poll slide, Prajay. A request to our audience, you have the poll slide in front of you on your screens. We would be most grateful if you could just give us your responses and feedback on today's webinar. We take your feedback very seriously. It plays a very important part in our continuous development of these programs. We are able to curate this specifically basis your suggestions. So please keep that going. The poll slide will be on your screens for the next few minutes. Thank you everybody for joining us, for taking your time. I hope this has been a worthwhile investment of your time. Thank you to our panelists for taking time out from your super busy schedules and in this preparation. To the audience, we'll send you a copy of the presentation, summary notes, and a recording link of this webinar. Please keep your feedback constant. Lawyers are vain creatures. We like good things said, but we also welcome any sort of suggestions for improvement. If any of y'all are interested in any kind of training or anything specific to Indian M&A landscapes, please feel free to reach out to us. Our contact information is on the contact slide here in front of you. Thank you once again, everybody, for your time, and keep watching this space for more M&A Academy programs from Khaitan and Company. Till then, have a good day. Bye-bye.